Hello everyone. Welcome to the session on Personal Laws Part 2, Matrimonial Causes. The objectives of this lesson are: firstly, to understand the meaning and types of matrimonial causes. Secondly, to outline the current law addressing matrimonial causes like restitution of conjugal rights, judicial separation, nullity of marriage, and divorce. Thirdly, to provide a comparative outlook of the matrimonial causes under the various personal laws. Lastly, to suggest the next steps for simplifying the remedial process. Let us start this session by understanding the meaning of matrimonial causes and the need for it. The legal remedies available at law to address disharmony in the institution of marriage are broadly termed as matrimonial causes. Restitution of conjugal rights, judicial separation, nullity of marriage, divorce, and alimony were traditionally part of the matrimonial causes in England. Every personal law in India provides for all or a few of them. Women today are looking at rowing out of troubled waters rather than continue in a troubled relationship. As with other aspects of patriarchy, the matrimonial remedies were mostly tilted against women, and the march towards gender equality and gender neutrality continues even to this day. Various matrimonial causes. There may be many marriages where the parties are not in consonance and hence require to part. Accordingly, Indian laws are made to address these. Usually, these modern attempts were grounded on principles of gender equality and provides options to women to address the problems they face in the institution of marriage. Even the International Covenant on Civil and Political Rights, to which India is a party, prescribes that parties to that covenant shall take appropriate steps to ensure equality of rights and responsibilities of spouses as to marriage, during marriage, and at its dissolution. The various matrimonial remedies available to a woman are restitution of conjugal rights, judicial separation, nullity of marriage, divorce, alimony, and custody of children. In this lesson, we would be addressing the first 4 items. We shall now examine the rights of women under restitution of conjugal rights. The parties to a marriage need to live together for the fulfillment of their marital obligations. When a party to a marriage unreasonably withdraws from the conjugal society of the other, then the person who is denied the company of his or her spouse may seek the intervention of the court for restitution of conjugal life. This modern remedy is unknown to the religion-based personal laws in India. This was introduced via the common law by the courts during the British India period for the first time in 1866 in Munshi Bazlur versus Shamsunesa Begum. This right is available both to the husband and wife. Decree of restitution of conjugal rights, hereafter called as RCR, could be passed in case of valid marriages only. A decree of RCR is an attempt to save the marriage by promoting reconciliation and requires the guilty party to live with the aggrieved party. However, a court cannot direct the guilty party be bodily handed over to the other spouse. Hence, failure to comply with the decree allows the aggrieved party to seek attachment of the respondent's property under Code of Civil Procedure or detention in civil prison. In the event of non-compliance with the decree, the aggrieved party may also move a petition after 1 year from the date of passing of the decree. Under Hindu law, the ancient Hindu law does not provide for this right. Section 9 of Hindu Marriage Act 1955 provides for the remedy of RCR. Any aggrieved spouse may apply to the district court for RCR. The court, after examining, may decree RCR. The burden of proof shall lie on the person who has withdrawn from the society. In 1983, the High Court of Andhra Pradesh in T. Sarita versus Venkat Subbaya held it to be unconstitutional. Later, the Supreme Court in Saroj Rani versus Sudarshan upheld the constitutional validity of the Section 9 of the Hindu Marriage Act 1955 and overruled the decision of Andhra Pradesh High Court. Under Muslim law, marriage between Muslims is a civil contract. Therefore, a suit for restoration of conjugal rights would be a suit for the specific performance of the terms of marriage contract. Under Muslim law, a suit in a civil court has to be filed if the husband either deserts a wife or neglects to perform his marital obligations without any proper reason. Then the wife can apply for RCR. When the suit is brought by the husband, the wife can contest it on the grounds evolved in various cases like cruelty, adultery, etc. The grounds of void and irregular marriages, exercise of option of puberty, and the provisions under the Dissolution of Muslim Marriage Act 1939 are also available to a Muslim woman. A Muslim husband can defeat a wife's petition for restitution at any time by pronouncing talaq on her. In Munshi Bazlur case, it was said that where a wife without lawful cause ceases to cohabit with her husband, the husband may sue the wife for restitution of conjugal rights. Under Christian law, Section 32 of the Divorce Act 1869 permits an aggrieved party to a Christian marriage to file a suit in the district court for RCR. On being satisfied of the truth of the statements made in the petition, the court may decree the suit accordingly. Section 33 permits the parties to plead the grounds of judicial separation or for a nullity of marriage as defense for RCR. Under Parsi law, Section 36 of the Parsi Marriage and Divorce Act 1936 deals with the restitution of conjugal rights. When either party to a Parsi marriage is deserted or is deprived of cohabitation by the other party without a lawful cause, such an aggrieved party may sue for RCR. Under Special Marriage Act 1954, the provisions for RCR under Section 22 of the Act are identical to Section 9 of the Hindu Marriage Act 1955 and are applicable to the married persons irrespective of their religion. Let us now analyze the provisions of judicial separation under the personal laws. Judicial separation is a matrimonial remedy that allows the parties to a troubled marriage to live separately from each other to reconcile their differences. The mutual rights and obligations arising from marriage are put under suspension. Such judicial separation is a last resort before the actual dissolution of marriage. Except for a few minor variations, judicial separation is similar under various personal laws. If the parties reconcile and agree to resume cohabitation after the passing of the decree for judicial separation, they can get the decree rescinded by applying to the court. Where there is no resumption of cohabitation between the parties, even after 1 year of the passing of the decree for judicial separation, it is a ground for divorce. During the period of judicial separation, non-consensual sexual intercourse by the husband with the wife would amount to rape under Section 376A of Indian Penal Code 1860. Under Hindu law, after the amendment of the Hindu Marriage Act in 1976, the grounds for judicial separation are identical with those for divorce under Section 13. A petition may be presented under Section 10 praying for a decree for judicial separation by a husband or wife on the grounds available in Section 13, subsection 1, and by the wife also on any grounds in the Section 13, subsection 2. Under Muslim law. So far, no provision of the statutory Muslim law enables the parties to the marriage to seek the remedy of judicial separation. However, Muslim law recognizes a right to live separately without an obligation to have cohabitation with her husband, though such claim can be made only in rare circumstances like cruelty or that her life is unsafe or other strong grounds. This order could be obtained by the wife in a suit instituted by the husband for restitution of conjugal rights. Under Christian law, parties to a Christian marriage can apply for judicial separation under Section 22 of the Act of 1869 on the grounds of adultery, cruelty, or desertion for 2 years or more. An aggrieved party can file an application in the district court under Section 23 of the Act. During the period of judicial separation, the wife shall be considered as unmarried with respect to property which she may acquire or which may devolve upon her. She can even dispose such property as an unmarried woman. Thus, Section 24 of the Act gives certain unique rights to a judicially separated Christian woman. Section 25 gives another unique right considering her as an unmarried woman. Her husband shall not be liable in respect of any contract, act, or costs entered into, done, or omitted or incurred by her during the separation. Under Parsi law, a party to a Parsi marriage can sue for judicial separation under Section 34 of the Parsi Marriage and Divorce Act 1936 on the grounds that are identical to grounds of divorce as under Section 32 of the Act. Under Special Marriage Act 1954, a man and woman married under the Special Marriage Act can seek judicial separation under Section 23 of the Act. The grounds for judicial separation are identical to the grounds of divorce that are given under subsection 1 and subsection 1A of Section 27 of the Act. A petition for judicial separation can be moved in the district court under Section 31 of the Act by either party. We shall now discuss on nullity of marriage. For a marriage to be valid under applicable personal laws, it needs to fulfill certain essential requisites prescribed by such personal laws. Non-observance of any of the essentials may make the marriage nullity, that is, either void or voidable. The Divorce Act 1869 and the Parsi Marriage and Divorce Act 1936 do not provide for voidable marriages. Under all Indian matrimonial statutes, a petition for nullity can be filed only by either party to the marriage. Since a void marriage is no marriage, a decree of nullity is not necessary. However, a voidable marriage is valid and binding marriage till a court passes a decree of annulment. Once a voidable marriage is annulled by the court, the marriage is deemed to have been void for all purposes from the very beginning. However, children of void and voidable marriages are entitled to a right in the property of only their parents, but not to other relatives. Under Hindu law, Section 11 of the Hindu Marriage Act declares a Hindu marriage void if it contravenes the conditions contained therein. As the parties lack the capacity to marry each other, even the conducting of marriage ceremonies does not confer the status of husband and wife. A petition for nullity under Section 11 of the Act can only be made by either party to the marriage. A third party may question the validity of the marriage and contest the rights claimed under such void marriage. Grounds like lunacy, impotency, pre-marriage pregnancy, consent by fraud renders the marriage voidable under Section 12. Under Muslim law, Muslim law makes a distinction between void and irregular marriage. Void marriage is an outcome of marriage through forced consent, plurality of husbands, prohibition on grounds of consanguinity or affinity or fosterage. The wife has no right of dower against the husband unless the marriage is consummated and neither of them is entitled to inherit from each other. A Muslim woman can have such a marriage declared void at any time. A Muslim marriage is said to be irregular when certain prerequisites are not fulfilled. An irregular marriage has no legal effect before the consummation, but when consummated gives rise to several rights and obligations like observance of iddat, payment of dower, among others. Thus, a void Muslim marriage cannot be made valid under any circumstances, but irregular marriages may be made valid marriages by removing the impediments. Under Christian law, a petition for declaring a Christian marriage as void may be filed under Section 18 of the Divorce Act 1869 on the grounds mentioned in Section 19 of the Act. But the courts have been declaring the marriage void on various other grounds too. Only the parties to the marriage may present a petition to the district court for the said decree. Under Parsi law, a Parsi marriage which violates the conditions outlined in Section 3 and 4 of the Parsi Marriage and Divorce Act 1936 are void. Further, a suit for nullity of marriage may also be filed under Section 30 of the Act where consummation is impossible due to natural causes. Under Special Marriage Act 1954, Section 24 of the Act outlines the grounds which lead to a void marriage. Further, marriage is voidable under the Act on grounds of non-consummation of marriage or pre-marriage pregnancy or obtaining the consent of the petitioner by fraud or force. Let us now see the approach of personal laws to divorce. Divorce means putting an end to the marriage by dissolution of marital relations between the spouses. The parties thereafter are not husband and wife. Today, every religion has its own divorce law. Divorce can be sought only on the grounds recognized by the applicable law. Grounds that are commonly found in the divorce laws are cruelty, desertion, adultery, unsoundness of mind, leprosy, venereal diseases, impotency, etc. Aggrieved party will have to file the case in a court of appropriate jurisdiction and needs to prove one of the statutory grounds. On successfully proving the case, divorce is granted by the court. While there is no time limit for divorce for a marriage solemnized in Christian form, the Hindu Marriage Act and Special Marriage Act does not permit a petition for divorce within 1 year of marriage except with the special leave of the court. We will notice that any wife except a Muslim has to undergo the judicial ordeal to avail of the divorce remedy. However, the Muslim woman is not really better off because she can be subject to unilateral talaq. Divorce by mutual consent has been recognized only in the recent past under Hindu, Christian and Parsi laws, whereas Muslim women had that concept under their personal law itself. Under Hindu law, divorce was unknown to the Shastric Hindu law. This new remedy was introduced by the Hindu Marriage Act 1955. The grounds for divorce available to both husband and wife are outlined in Section 13, subsection 1 and subsection 1a. Additionally, grounds for divorce are available to the wife under Section 13, subsection 2. Section 13b of the Act lays down that a petition for divorce by mutual consent may be presented jointly by both the spouses on the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together and that they agreed that the marriage should be dissolved. This new method of divorce enables the parties to seek divorce without resorting to false grounds to succeed in their divorce claims. Under Muslim law, a valid Muslim marriage is dissolved upon the death of the husband or the wife. On death of the wife, the husband can marry immediately, but in the case of death of husband, the wife can marry only after the completion of iddat. A Muslim male may divorce his wife by uttering the triple talaq at any time without assigning any reason or judicial intervention. However, a Muslim wife does not have a similar right of talaq. Therefore, Muslim women live with a perpetual fear of triple talaq. Muslim women can repudiate her marriage and get a divorce from her husband by talaq-e-tafweez or khula or zihar or lian or fasq or under the Dissolution of Muslim Marriage Act 1939. But they all either require the mutual consent or judicial intervention, unlike the husband's unilateral power of talaq. Few acts or omissions on behalf of the husband give her further rights to seek divorce under Section 2 of the Act of 1939. To get the marriage dissolved under the Act of 1939, she has to file her petition for the divorce under CPC. The judicial divorce does not affect any right of dower, and she is entitled to half dower even if the marriage is not consummated. Section 3 of the Muslim Women Protection of Rights on Divorce Act 1986 requires that meher or other properties of Muslim women shall be given to her at the time of divorce, thus protecting her rights on divorce. Thus, the Acts of 1939 and 1986 provides some relief to Muslim women, thus contributing to gender equality to some extent. Under Christian law, any spouse can file an application for divorce on the grounds enumerated in Section 10 of the Divorce Act 1869. While Section 10 subsection 1 of the Act provides grounds of divorce that can be invoked by either husband or wife, Section 10 subsection 2 lays down the grounds that can be invoked only by the wife. Section 10A provides for divorce by mutual consent by both the parties together, analogous to the Section 13B of the Hindu Marriage Act, except that the parties must prove that they were living separately for more than 2 years as against 1 year under the Hindu Marriage Act. The Supreme Court is currently examining if the 2-year period is reasonable, as other laws prescribe only 1 year. Under Parsi law, a Parsi husband or wife may file a suit to dissolve the marriage under Section 31 of the Parsi Marriage and Divorce Act 1936. Parties may sue for divorce on any one or more of the grounds provided under Section 32 or 32A of the Act. Section 32B provides for divorce by mutual consent and is analogous to Section 13B of Hindu Marriage Act 1955. However, no such petition can be filed in the first year of marriage except with the special leave of the court. Under Special Marriage Act 1954, while Section 27 provides grounds that can be invoked by either party to a marriage, Section 27A lays down the grounds that can be availed by the wife, analogous to Hindu Marriage Act 1955. The court can pass a decree for judicial separation instead of a decree for divorce if it considers just. Divorce by mutual consent is also permitted under Section 28 of the Act, analogous to Hindu Marriage Act. We shall now conclude with a few words. From the journey above, one is hit by the plurality of the laws and procedures that govern a very basic aspect of matrimonial causes. Except for the Muslim women, women under other religions are provided with matrimonial remedies only in the recent past to walk out of their troubled marriages instead of enduring it endlessly. One can notice that overall, the grounds for matrimonial remedies are similar under various personal laws with some minor variations here and there. But the procedure to enforce these remedies and forums are different. Today, it is universally accepted that marriage, inheritance, and the like are considered as matters of secular law. The Supreme Court of India, in a number of judgments, has expressed similar views and asked the legislature to enact a secular law applicable uniformly to all citizens of India for addressing them. Such a secular exercise can alleviate the gender injustice that still exists in pockets of personal and codified law. Hence, a start may be made in the journey to secular uniform law by first attempting a uniform legislation on the matrimonial remedies. Hope you have enjoyed this session. See you all in the next session. Thank you.